trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome. As this is another attempt, because what's happening is now you have to be a subscriber to this channel, and you have to be subscribed to this channel for over 5 months to become a moderator, and you have to be somebody I can trust. But hello, everybody is coming in tonight. So YouTube will actually strike you for music in ads. And I got a bunch of stuff removed. So if I'm not responding to you in the chat, please understand that I'm trying to watch what's being presented to you, so I can skip the ads so it doesn't get channel struck. However, if people are just flagging this channel just to get rid of my channel, then I will stop doing this, because I'm not going to waste my time trying to build something for other people to take it down. So it's just a thing that I'm trying to build something here, and people are trying to take it down. But I can see where YouTube, it'll get you for ads. If the music in an ad shows up, it gets copyrighted. So like I said, if I'm not paying attention to you in the chat, it's because I'm trying to pay attention to what's being presented to you, so that I can skip the ads without getting the channel struck every time. But today it's going to be Judge E Lynisse Bryant, and I'm still working on the schedule, so if you guys, if you're new here and you like this kind of content, please do me a favor and subscribe to the channel and make this channel grow, make this channel go bigger. I appreciate that. I appreciate the thumbs up too, you guys. So today is Judge E Lynisse Bryant, and I think I got all the bugs worked out of everything. So let's share screen. Judge Bryant. Okay, let me come back and do this. Make it larger. Let me go back to YouTube and
This is case number 2345640. Oh man, what? I'm
I can't hear again.
Oh, geez.
You're not muted.
All right. Let's. All right. He gonna come back. He gonna leave and come back again so he can hear. Okay.
Good morning.
Why would you say good morning
I
and you
still
can't
can't hear
hear?
though.
I mean,
I
so
can't hear you.
why would he keep interrupting us and he can't hear? Okay. All right.
Hold up. Before we dive into this absolute train wreck, you need to know what we're dealing with. A 23-year-old woman, 5 drinks deep, telling a judge she didn't feel drunk. Judge Bryant is about to deliver one of his legendary reality checks that'll leave your jaw on the floor. This isn't just about drunk driving. It's about a dangerous mindset that could have killed innocent people. Buckle up, because this sentencing is going to be brutal.
Case number 244456201. The People versus Janiyah Alea Thompson. Defendant is charged with operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Dawn McLeod on behalf of the people.
The world's first titanium nonstick pan. It's gonna blow your hair back.
What if your eyes could
Good morning, Mr. Williams. That's going to be my last attempt because it is 11:56. Mr. Williams was scheduled this morning at 10:30. And it's 11:56, just in case you didn't know. Mr. Williams was scheduled this morning at 10:30. It's 11:56. Okay, we'll put him in a breakout room. It's 11:56. It's 11:56. Okay.
I don't need a breakout room from Mr. Williams. Your Honor.
You should, because you should.
Okay.
That the judge might not even hear your case this morning, because it's 11:56. It's 11:56. He was scheduled at 10:30. So you might want to ask him, why is he just coming in my courtroom at 11:56? All right, this is case number 234416301. The People versus April Marie Hollins. Defendant is charged with 1 count of guns possessing while operating under the influence, and today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. May it please the court, Thea Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. April Hollins. Ms. Hollins, ma'am, will you please say your first, middle, and last name?
Morning, April Marie Hollins.
Today is the date set for sentencing. On behalf of the people, are there any additions, deletions, or corrections to the pre-sentence report?
No, Your Honor.
On behalf of the defense, are there any additions, deletions, or corrections?
Your Honor, on behalf of Ms. Hollins, we've had the opportunity to review the pre-sentence investigation report. Judge, can you give me just a second? I'm having a problem with the iPad. On behalf of Ms. Hollins, Your Honor, we've had the opportunity to review the pre-sentence investigation report. We did find it to be factually correct. We have no additions or deletions at this time. Ms. Hollins does stand ready for sentencing.
On behalf of the people, anything as to sentencing?
Your Honor, the only concern the people have is that Ms. Hollis submitted to a analysis that was positive for drugs and alcohol, marijuana and alcohol. And so that is a concern considering this particular offense involved alcohol. Other than that, the probation department has recommended or submitted a fair recommendation, and we'd ask the court to adopt it.
Ms. Stevenson?
So, Your Honor, we want to, when I happened to be down at the probation department on the day that Ms. Hollins submitted, started her pre-sentence investigation, and she had to go do her urinalysis, and she was like, I didn't know I wasn't supposed to drink.
She's not being honest. She's not being honest.
So I looked at it again today, and I did advise her. I'm like, okay, I don't think it's true that you didn't know. I do think it's true that you forgot, because the order was given. I think we've been moving through this case for about a year. But I said that just to say, so that the court could know that Ms. Hollins was at least doing what she could do. She wanted me to come talk to you about it on the date that she went to the PSI interview. She just was trying to be upfront, and that's the reason I brought that to the court's attention. So Ms. Hollins, I did ask her about her source of income, and she said that she used to work as security, and she's trying to get back into that field at this time. If she can't get a job doing security, then she's trying to get a job doing retail work. But she gets food assistance. That's the only other source of income that she has. So at first I was looking at the community service recommendation from the probation department, and I thought that was a little bit excessive. I've changed my mind on that because, I think that the court did remind us that somebody in this courtroom mentioned that sometimes when people do community service, that turns into a job. And I think that would be very helpful for Ms. Hollins. So, the charge that she's here for is that she is in possession of a firearm under the influence. We don't have anything like that reoccurring since the time she started coming to court on this case. She's been here. She's been in communication with me. She doesn't have any prior criminal history. She's not trying to avoid any responsibility in this case. She knows that she's probably facing an advanced sanction because of consuming alcohol while she was on probation. But I do believe, despite that, Your Honor, that Ms. Hollins knows how to follow directions, and she intends to do that so that she can move past this. And so I'm asking the court to follow the probation department's sentencing recommendation. Place her on a term of probation with which I believe she will speedily comply. Let her move forward with her life, Your Honor.
Are you researching dental implants?
Address the court.
Ms. Hollins?
Yes, ma'am. I do understand that of my sentencing today, and I am willing to fully cooperate with the courts and the probation to move on and succeed in a timely manner with my probation.
Court is ready to impose sentence. I do so as follows. The probation department has recommended a term of probation of 12 months. I'm going to accept the recommendation for probation. However, the term of probation is 15 months with a final review date of January 14, 2026, an interim review date of February the 12th, 2025 at 10 o'clock a.m. The terms of the probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of address, phone number, or employment status. You will pay the following fines, costs, and fees. The mandatory cost of $210, $100 attorney's fee, $400 fine, $525 oversight fees. That is at a rate of $35 a month. For the halfway point, it would be $263. A $100 assessment fee. Court is not going to impose the urinalysis fees, but that's because she can test outside the court if she was testing outside the court. And then the total fines, costs, and fees, not including any urinalysis or classes, is $1,335. For the halfway point, it would be $1,073. Additionally, you shall not use or possess any illegal substances. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. You shall not use or possess any handguns or firearms. You shall attend alcohol highway safety education level 1. You shall submit to random urinalysis twice per month. You shall attend outpatient treatment, Alcoholics Anonymous. You will complete 10 days of community service. That's equivalent to 80 hours of community service. You will attend the Victims Impact Panel, watch the consequences video. You will pay outstanding tickets that you owe with the 36th District Court. You will clear up all warrants that you have. You will attend the Choices program. Your first date, as I indicated, is February 12th, 2025 at 10 o'clock a.m. We will mail a copy of this order to the Crescent Drive address, and probation will contact you at the phone number ending in 8536. Anything further?
Nothing from the people.
Your Honor, we have heard the court's order, and absolutely Ms. Collins has indicated she intends to abide by the court order. I'm just with regard to the alcohol highway safety education program. Would the court be ordering that this was not a drinking and driving related offense?
She was had a gun while operating under influence. What are you saying?
I believe she was a passenger.
No, Your Honor.
Say that again.
I believe she was not operating a motor vehicle, Your Honor. There's no allegation that she was operating a motor vehicle.
Are we talking about, we're saying April Marie Hollins?
Yes, Your Honor, is charged with being in possession of her firearm while under the influence.
I apologize. Can somebody tell me what O stands for? What does O stands for? So, because I'm looking at the docket. So when I called the case, nobody corrected the case. Also on the, well, it is maybe correct. It says possession under the influence on the thing. So when I called the case, nobody corrected the case. It's OUI. So I don't know. I don't have the thing. So this says gun possessing, OUI, operating under the influence. Isn't that what that stands for?
I'm not sure what it stands for, but she's charged with weapons, firearm possession under the influence.
Mr. Flanagan, so can we change it then?
Oh, yes, Your Honor, that's what it is in the system. Weapons, firearms, possession under the influence.
So help me then. Why? Help me. That y'all not being honest. Help me with what is OUI on the docket then? Just tell me. I mean, somebody tell me. Mr. Flanagan, tell. What is gun possession OUI? What is that?
Operating under influence.
I know. So it's in wrong then. So somebody put it in wrong. It couldn't be correct. Somebody put it in wrong. It's in wrong because it's OUI. That means operating. The O stands for operating under the influence. But okay. So the O shouldn't be there. It should be just gun possession under the influence. Okay. So therefore, I will take away the victims impact panel and the consequences video and the driver's improvement program. All right. And the alcohol highway safety.
Okay, how did the Powerball and Mega Millions
See how 4 things come off because of that O? Okay. So that is, okay, let's correct it. Let's correct it. Let's correct it. All right. She has 3 warrants with the 36-digit court, so she needs to clear those up right away. Oh, I did not order, but let me go back. So I am gonna add, I didn't add it, the handgun intervention. I will order that as recommended by the probation. So we're removing alcohol highway safety, we're removing victims impact panel, the consequences video and driver's improvement. Those are removed from my order. And then we are adding handgun intervention. All right, anything further?
Nothing from the people.
So, Your Honor, Ms. Hollins does have a phone number for Judge Millhouse's courtroom, and she'll call them and get those warrants taken care of as soon as we get done in here today. Would the court consider outpatient treatment if there are any further positive tests rather than ordering that up front, Your Honor?
No.
Other than that, we have nothing further, Your Honor.
Okay. And let me just be clear as to why I'm not going to do that. I'm clear. I'm clear. When I speak, I'm clear. And yeah, when I speak, I'm clear. And so you can say she forgot and she can say she didn't know. But that also says to me then that she either didn't listen or didn't care. But I'm clear when I speak. So if it had been another judge that ordered that, maybe then I would say I can't guarantee that they told her. But I know that on at least 2 occasions, I said bond will continue, no drinking and no driving without a valid license. I say it. So we're going to go ahead and do outpatient treatment. And if the outpatient treatment people say that she doesn't need it, then I guess we'll go from there. But no, it's in the order.
Okay. Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe.
Thank you.
We're going to mail a copy of the order, if I didn't already say that, to the Crescent Drive address. And probation will contact you at the phone number ending in 8536. All right.
So Judge, I need to go into the courtroom and talk to Mr. Lindsay
Sure.
and talk to Mr. Williams. Which of those should I do
No,
first?
oh, I didn't mean to do that. Why? I didn't. Okay, they done reported the girl to Zoom.
Sometimes even the judges have a problem with technology.
No, go do Lindsay.
Okay.
I'm ready. Where's Mr. Lindsay? All right, this is case number. Case number,
Why you should never cover your credit card.
0621650, the people versus Edmund Lindsay. Defendant is charged with license plate illegal use. Today is the date set for review. Appearances, please.
Janice Stevenson appearing on behalf of Mr. Edmund Lindsay. Mr. Lindsay, sir, please say your first, middle, and last names.
Edmund Hampton Lindsay Jr.
All right, Ms. Stevenson.
So the court did adjourn the matter, Your Honor, from this past Friday for today for Mr. Lindsay to come to court in person, which he has done. The court did previously extend the probation to give Mr. Lindsay an opportunity to do community service in lieu of costs and fines. Your Honor, Mr. Lindsay has not, because of health conditions, been able to complete the community service. He did hear the court say, I believe it was on Friday, that there would be other community service opportunities available to him, which would not cause him to have to walk around, which he can't do because he has a hip injury.
I just seen him walking. What are you saying?
I have 2 broken hips, man.
I don't know who he's talking to, but what I'm saying to you, Miss Stevenson, is that I just saw him walking. I also know people who had 2 hip replacements, right? I don't see him on a cane, on a walker, in a wheelchair. Furthermore, I didn't say there would be opportunities available to him, because there's always been opportunities available to him. We have a thick book of places that have community service. So, okay, come on.
Yes, we do not represent to the court that Mr. Lindsay can't walk, Your Honor, but what he's indicated to me, and what I think he reported last week, is that because he's scheduled for the hip surgery, he did not understand that there were other opportunities that were available to him. Now, I did talk to him about the reason he didn't understand that, and I think it comes down to Mr. Lindsay not interacting with his supervising probation officer in the way.
You're talking about the probation meetings that he missed in July, August, and September.
And I think that's what's causing the disconnect for Mr. Lindsay, Your Honor. But I don't believe that Mr. Lindsay is trying to run from the court. I believe exactly the opposite. I think if Mr. Lindsay were trying just to totally disregard this court's authority, once he had a pretty bad hearing on Friday, once he could see where this is going, I don't think he would have made it down here. I don't think he would have stayed out in the hallway until about an hour ago. I don't think he would have kept knocking at my door trying to get my attention if he were not trying to handle this matter. So I don't think Mr. Lindsay's trying to run. He told me that his source of income is plasma donation. He does have children. He's using a bicycle when he can for transportation. So I'm not, you know, the charge involved Mr. Lindsay doing something that I think is, you know, kind of strange, that he doesn't go down to the Secretary of State and get his plate the way every lawful driver does. He did something different. Plate has to come from the Secretary of State and has to go on the card that they say it's supposed to go on, and he didn't do that. And he pled guilty to that, and that's what he's here for today, Judge. So
I know, and that's why it's a shame. That's why it's a shame if he has to go to jail. That would be his own doing. He's literally been on probation for 13 months. So now you tell me what you want me to do. He's literally been on probation for 13 months and still has to do the same thing he had to do 13 months ago that he has not done. So how much more grace and mercy? Come on, just tell me.
Until the day that is the day there are no more. I don't know. I want grace and mercy to continuously flow. And
today is kind of the day that there are no more. But okay, sure, Ms. Stevenson. So 13, 14, 15, 16, 17, 18, 19, 20. And then that's 7, 8, 9, 10, 11. Okay, let's just go. Let's go. Let him go across the hall. You say he's not running, but he has 3 other warrants out for his arrest. You say he's not running from the law. You say the fact that he showed up means he's not running. Well, maybe he just got tired of running. He's been running. Maybe he just got tired of running. But
well,
hey,
I know he's not running this court, and so he's not disregarding this court authority to the rest of it. But he's here to face the music with you, Judge.
Okay, well, let's face the music again in January. Because you want me. Let's just keep facing me. Let's just keep dancing to the music. Okay. Until there's no more music to dance to. January 14th. He's going to go across the hall today. He's going to go see Miss Bumpus today. If he fails to see Miss Bumpus again, I'm not going to do this. So it costs nothing to meet it with his probation officer. He doesn't have to use his legs. He doesn't have to, he can call her on the phone. He can do whatever. Listen, okay, January the 14th, 10:02, in person. Anything further?
Not at this time. Thank you very much, Your Honor.
You're very welcome. All right, let's see if he'll go across the hall and talk to Ms. Bumpus today. All right, I'm ready on Williams, who was 2.5 hours late for court. But what I'm not going to do is continue to wait for Mr. Williams. Case number 194604201, the People versus Dedrick Anthony Williams. Defendant is charged with license plate illegal use. Today is the date set for trial. Appearances, please.
Good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Dedrick Williams. Mr. Williams, sir, please say your first, middle, and last names.
Ms. Stevenson, what are we doing here? He was 2.5 hours late for court.
I'm sorry.
Late for court.
Say your first, middle, and last names, Mr. Williams.
Dedrick Anthony Williams. I'm sorry, I couldn't hear you, man.
All right. Today is the date set for trial. Are the people ready to proceed?
Yeah, but unfortunately, the people are not able to move forward on this matter. There was the case was supposed to be reassigned because the officer in charge was not no longer there.
Oh, okay.
And yeah, subpoenas were sent. Involved the use of a yellow plate. That was the allegation, and it's from 2019, and so we're not able to move forward.
Your Honor, we would apologize to the court for our tardiness. Unfortunately, Mr. Williams found himself arrested and had to walk from the jail. He's back at home now trying to get to the urgent care. We would move for dismissal, Your Honor.
All right, the court is going to grant defense counsel's motion to dismiss as the people are unable to proceed. Today is the date set for trial, and the witnesses have not appeared, and it is 12:34. We will mail a copy of the order of dismissal to you for your records. Anything further with respect to Mr. Williams?
Nothing from the people.
Nothing on behalf of Mr. Williams. Thank you, Your Honor.
All right, Mr. Williams, I hope you feel better. Have a great day. Stay safe.
You too, man. I'm sorry for being late.
I accept your apology. Sound like you had a decent reason.
I did, man.
All right. All right. Bye, Ms. Stevenson. You brought me out there today.
There's always.
I don't know what time they wanted to bring Mr. Lake, but they'll have to try again tomorrow. All right.
Check this out.
Track. So now you're at the end of the line. So I'm not real sure why you're rolling your eyes on the court. This is your fault that you're getting a date in February. Like 5 times.
I have people, ma'am, excuse me.
I'm not sure why you're interrupting me. I don't know why. And I need Ms. Davis to come on to the screen. I've tried to bring you onto the screen so many times. And in a minute, I'm getting ready to capious you, and your bond is going to be $10,000 cash surety plus a GPS tether.
Welcome back to the channel, everyone, and buckle up, because today's court of responsibility by shifting blame. Judges' rulings are going to keep you hooked
to me. I don't know why. I have no idea why you're interrupting me, but please stop. I'm ready on Deshaun Williams because I didn't say remain seated in an upright position unless. I didn't.
Right off the bat, Judge Bryant sets the tone. No nonsense, no disrespect. Court isn't casual. It's not a Zoom hangout where you can roll your eyes or talk over the judge. Judges expect defendants to appear professional, seated upright, attentive, and ready. Because it shows respect for the legal process. Rolling your eyes at the court may not land you in jail instantly, but it definitely impacts how the judge views your credibility and attitude. Let me ask you, if you were the judge, would you trust someone who couldn't even keep a straight face in court?
I didn't. And I also said, please do not unmute yourself until asked to do so by the court. Like we give the instructions for court at the beginning of court. We do. This is case number 20-602-1101, the people of the state of Michigan versus Deshaun, middle name may be Devon Williams. The defendant is charged with license plate, illegal use, driving while license suspended, revoked, denied, driving on an unregistered motor vehicle. Today is the date set for review at 10:05, meaning that at the last review date set by the court back in December that the defendant failed to appear. Ms. Stevenson, your appearances, please.
Janice Stevenson on behalf of Mr. Deshaun Williams. Mr. Williams, sir, please unmute and tell the judge your full name.
Deshaun Devon Williams.
Thank
I
you.
have somebody working on my apartment, man. So,
Sir, that's not what's going to happen. 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 That is not what's going to happen. That is not what's going to happen. Now, if that's how you need to attend court today, then you need not to attend court today. But you're not going to overtalk us.
Here we see one of the biggest problems with virtual court, defendants unmuting themselves and interrupting. Judge Bryant reminds him multiple times, don't unmute unless asked. Think of court like an orchestra. The judge is the conductor, and everyone else has a role. If one person decides to jump in out of turn, it creates chaos. The legal takeaway here? Every courtroom has procedures. Ignore them, and you're not just being rude, you're putting your case at risk.
You're not going to explain your personal at-home situation to us because the court is open. ready for business. If your home was not conducive for you to attend court this morning, then you should have come in person. As I indicated, I'm not going to compete with whatever you have going on. I said that 3 or 4 times this morning. Ms. Stevenson?
Your Honor, I actually I'm going to ask the court if I can just go back to break out with Mr. Williams.
Well, you may need to, because he's on his way to get his probation revoked, because I'm not real sure.
Notice how Williams tries to explain that someone is working in his apartment, but Judge Bryant cuts him off. That's not what's going to happen. But because excuses don't erase responsibilities. Court is court. If your environment isn't quiet, you're expected to show up in person. Judges have heard every excuse under the sun: bad Wi-Fi, noisy kids, construction. But none of that changes the fact that you're required to be fully present. This is a powerful reminder. If you want leniency, you start with respect, not excuses.
Why he thinks that today he's going to be hostile towards the court. I'm not
just have another quick minute with Mr. Williams.
Okay, you may have a lot of minutes with Mr. Williams to save him from what he's getting ready to be engaged in. All right, I will send him to the breakout room. Stevenson, anything? I don't remember where we left off with Mr. Williams.
We were at the very beginning.
Oh, okay. Let me get this file. And I need Ms. Davis to come on to the screen. I've tried to bring you onto the screen so many times. And in a minute, I'm getting ready to case you, and your bond is going to be $10,000 cash surety plus a GPS tether. All right, so I'm back on the record with Deshaun Williams. And Ms. Stevenson?
Again, for the record, Janice Stevenson on behalf of Mr. Deshaun Williams. Mr. Williams, sir, please unmute and tell the judge your full name.
Deshaun Devon Williams.
All right, today is the date set. I don't have anything up there. For review for Mr. Williams, he was last scheduled to appear before the court December the 15th, and I did have an update at that time. However, I believe that Mr. Williams failed to appear and his matter was adjourned to today. So that update, I don't know if it is accurate today or not. Ms. Stevenson, you should have still had it from December. I think I sent it to you back in December.
And there is some updated information, Your Honor. At this point, Mr. Williams has indicated he's completed all 122 hours of the community service. He's working with through a referral, which Ms. O'Driscoll gave him for Detroit Works, trying to take care of whatever there's an individual who's helping him through Detroit Works to get on top of any outstanding traffic matters he has at 36th District Court. He's also trying to get some more regular work. He does do odd jobs, Your Honor, so that he'll be able to get together enough money to pay the balance of the costs and fines. But I think that's all that's left. The community service is done. Mr. Williams keeps regular contact with Ms. O'Driscoll and is using the resources that she's made him aware of. So
what happens to your brain 15 minutes after eating honey?
Williams' own attorney admits it. He's on the verge of having probation revoked. That's serious. Probation is essentially a second chance. Freedom with conditions. Blow it and prison is waiting. Judges don't revoke probation lightly, but when someone keeps showing attitude, missing court, or failing to comply, revocation becomes inevitable. Here's the big question. Do you think Williams is sabotaging himself, or is he just overwhelmed by the system?
I'm going to ask the court to give Mr. Williams an opportunity to continue to work on the monetary balance. I don't know how much that is, Judge.
Mr. Flanagan, what is his balance for this case? I only imposed $385. No, that's not the truth. He had several counts, but at a certain point, I think I changed some of it to community service. So he had $335 on count 3, $385 on count 2, and $1,085 on count 1. And at some point I converted maybe all of it. Count 1, I converted down to 210, count 2 and 3, I converted each down to 185. Mr. Flanagan.
Yes, Your Honor, that's what the ROA is showing for count 1, 210, for count 2, 185, and for count 3, 185.
And that's still the balance?
Yes.
All right, and he had $6,000 that he was owing on traffic tickets. Give me 1 second. Where did I just leave off? That threw me off. Ms. Stevenson, did you hear me?
At the amount of money that was calculating the amount of money that was owed.
Okay, so he still owes, oh, I was gonna calculate this. So, I mean, the $6,000, that's, he owes a lot trying to get on a payment plan. 25% of 6,000 is 1,500.
And I think that's what he's working with Detroit Works.
Now, let's talk numbers, because Judge Bryant goes through the math carefully. At one point, Williams owed thousands in traffic fines. Some were reduced to community service, some were converted to smaller amounts, but there's still a balance, $580 left. Courts often allow payment plans or community service to help defendants, but ultimately, the balance must be cleared. This breakdown shows how courts balance punishment with practicality. But here's the real kicker, $6,000 in unpaid traffic tickets. Imagine letting your fines stack that high. Would you have handled it differently? Or is this just the result of years of small mistakes adding up?
On, Your Honor. Try to get that down somehow.
Okay, so he was placed on probation December of 2021. We almost out of time. Did he KP it? Well, no, I mean, it's at 10:05, but December 2021, he's running out of time.
So, Judge, if he can, how much is he owe left in this case, Judge?
You didn't add that up.
I didn't. I was just looking for the bottom number.
He owes $580.
Okay.
The judge calculates 25% of $6,000 equals $1,500. That's the minimum down payment Williams needs to show good faith. This is a classic example of how courts demand accountability. It's not just about paying everything at once, it's about proving effort. But here's the irony. While Williams argues and interrupts, his lawyer is working hard to negotiate on his behalf. It's a reminder that sometimes defendants are their own worst enemy.
The answer to your question is no, though. I mean, you want to say if he paid the $580, am I not going to hold him to getting on the payment plan and stuff?
No, if he pays the $580 and then gives the court some verification of what he's trying to do through this, through Detroit Works, Your Honor, to try to resolve the outstanding matter, I would be asking the court to then maybe close the matter if he's doing what he can do. It's a lot of money, that $1,500.
Okay, well, we'll see. Let's see what Detroit Works says.
Okay.
All right. So let's continue him to August the 30th at 10 a.m. Anything further?
Nothing on behalf of Mr. Williams. Thank you very much, Your Honor.
All right, you're welcome. Ms. Davis, Mr. Williams, have a great day. Stay safe. Ms. Davis, this is your last opportunity.
She's calling me right now, Judge. Can I see what?
We'll see, because Ms. Ritter has to go, and Ms. Davis is, I don't know what's her issue.
Okay, can I just have 1 second?
Yeah. Oh, and then I need you to call your client and ask her, is that her in the breakout room? Because I'm not letting her in, Ms. Sanders. I think that's Tony.
Okay.
Yeah, see if you can call her and see if that's her.
Okay.
Okay. Must remain seated, stationary, in an upright position, and ready to attend court. No matter where I send you, you must remain seated, stationary, in an upright position, and ready to attend court. This is case number.
The world's first titanium nonstick pan. And blow
22571-1901, the people of the state of Michigan versus Andres, middle name might be Tynique, it might be cut off, Tynec Bohannon. Defendant is charged with 1 count of retail fraud, and today is the day set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Andrews Bohannon. Ms. Bohannon, ma'am, please unmute and tell the judge your full name.
Hi, Judge. My name is Andress Tynesia Bohannon.
Today is the day set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Bohannon will continue her plea of not guilty. Your Honor, I think we had a prior missed court date, but I am asking this to go on the jury trial track.
Court will continue a not guilty plea on behalf of Ms. Bohannon, and I will place the matter on jury trial track.
Judge Bryant gives Williams more time, until August 30th, to pay $580 and show proof he's working with Detroit Works. That's leniency, but it comes with strings attached. Miss it, and consequences will be severe. This is where courtroom drama meets real life. Deadlines, money, second chances. For you watching, what do you think? Should Williams get more time, or should the judge have cracked down harder?
Did she miss her court date at the time that I was getting ready to give her a jury trial? Or was she already on jury trial track?
I think she was supposed to get on, well, the note that I had is on December 15th, we had a final pretrial. We were adjourned to April 6, 2023 for a final pretrial to be placed on jury trial track.
Court is going to place the matter on jury trial track, setting a final pretrial date. I think I was setting final pretrials for at least February. Mr. Flanagan, I mean, you the one, KPS, what you rolling your eyes for? You were getting ready to be on jury trial track. So now you're at the end of the line. So I'm not real sure why you're rolling your eyes on the court. This is your fault that you're getting a date in February.
I was there. I was in the courtroom April 6th.
Yeah, okay.
Yeah, you didn't never let me in the courtroom.
Because
I recorded it.
And I know it's a reason. Oh, she probably came very late. How many people do we not let in the courtroom? Can anybody tell me if I've never let somebody not come in the courtroom who were on time and ready for court?
The court date was April 5th, Your Honor.
Okay.
She wasn't admitted.
And what, April 5th, April 6th? So Ms. Bohannon wants me to believe that she came to court on time, and then we just left her sitting in the waiting room. And we said, we're not letting her in court.
Now we switch to defendant number 2, Ms. Bohannon, charged with retail fraud and claiming not guilty. Right away, there's tension. She missed a previous court date, and now she's rolling her eyes at the judge. That's a bad move. Judges notice body language. An eye roll in court isn't just disrespect. It's like shouting, "I don't take this seriously." Question for you. Do you think eye rolling should be punished, or is it just frustration spilling over?
That's what happened. What date are your notes from, Ms. Stevenson?
From, so on December 15th, it was placed, it's his final pretrial conference for jury trial track for 5/23, Your Honor.
So December 15th, Ms. Bohannon, final pretrial conference held, not guilty, continued. Final pretrial adjourned to April 5th at 9:17. And then on April 5th, I heard Miss Brenda Holmes' case. I heard Cheryl Modrick's case. I heard LaShawn Davis, Amari Banks, Joseph Fields, Jacqueline Flint, Juan Moran, somebody last name Boggs, Jessica Jackson, Adam Mazon, Joseph Grice, Lakia Gill, Verde Wilson. I don't have anybody's name, Bohannon. Mr. Flanagan, what happened on April 5th? What do the notes say for April 5th for Ms. Bohannon?
It was a miscellaneous action, and it was scheduled for final pretrial for today.
So what happened? Probably was Ms. Bohannon, she came late. And was I in trial that day? April 5th. I don't see any trial notes on here. So Ms. Bohannon, she probably came late. And then I gave her the courtesy of putting it on this date. But now what it appears that perhaps it should have been at 9:17 instead of at 9 o'clock.
Bohannon argues she showed up for her April court date but wasn't let in. Judge Bryant doesn't buy it, because court records tell a different story. Judges document everything: times, dates, who appeared, who didn't. Claiming the court simply ignored you is almost impossible to prove. It also comes across as an excuse rather than accountability. Here's the bigger issue: missing court is treated seriously. It can lead to warrants, fines, or worse. So the question is, do you believe Bohannon, or is this just another courtroom excuse?
But what Ms. Bohannon is not going to do, so Ms. Bohannon, let me tell you what's going on right now. What you're doing right now is equivalent to coming up to the podium and turning your body to the side. Coming up to that podium, turning your body to the side. You're going to stop doing that. You're going to stop doing that.
Speed up new construction and remodeling jobs with Froth.
Now, if you continue to have an attitude, the matter is probably not going to be resolved in the fashion that you want it to be. But if you can muster up some respect for the court and for the court process and indicate things in a respectful way, then we'll continue to look into what you're saying. So it appears that on April the 5th, Ms. Bohannon's matter was not heard. And the only reason that could be because I would never not let a person into the courtroom, because as we can see, I was present and working that day. And I clearly have nothing against Ms. Bohannon. I don't know Ms. Bohannon, and I would not have just said I'm not going to let Ms. Bohannon into the courtroom. Nonetheless, at the time that we adjourned the case, Ms. Bohannon should have already been on the jury trial track at 9:17.
Here's where Judge Bryant draws the line. She tells Bohannon to stop turning your body to the side, a metaphor for her attitude. In other words, stop resisting, stop rolling your eyes, and start engaging with respect. Judges can be stern, but they also give warnings before harsher actions. This was that warning. It's a fascinating moment. Bohannon had a chance to reset her tone. Will she take it?
The record does not reflect a capias, nor is the matter set at 9:05. Therefore, since she was apparently already on the jury trial track, despite the fact that she did not indicate that in a respectful way, the court is going to give a jury trial date. Anything further with respect to this matter?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Bohannon. Thank you very much, Your Honor.
All right, then you're very welcome, and we are all set until November the 17th at 9:10 a.m. Have a great day and stay safe.
Judge, she's trying to switch devices. There's an internet problem where she is, so she has to get off of the internet device and try to get on a mobile device. Your Honor, Ms. Davis indicated she's trying to put Zoom on a mobile device.
We don't have time for that
device.
You saying she got to download the app and do all of that?
That's what it looks like.
She was supposed to practice this yesterday. What happened? You all have a plus sign behind her name.
Yes, we were able to interview Ms. Davis in the breakout room, Your Honor, have talked to her about her case. It's just that she was using a device which was dependent, I guess, on the Wi-Fi, and she said that somebody hit a pole and there's a problem with Comcast.
Ms. Davis needs to get on the court tomorrow. She's going to come to court tomorrow in person.
Okay.
Because Ms. Davis is getting ready to have a warrant for her arrest for $10,000 cash surety plus a GPS tether. She has capias on this case about 5 times. So she better get to court. tomorrow morning, 8:30.
Okay.
Ms. Riddle, you may leave.
Thank you, Judge. Everyone have a good day.
In the end, Judge Bryant gives Bohannon what she wanted, a jury trial date. But make no mistake, this wasn't because of her attitude. It was because the law required it. Judges often separate personal frustration from legal obligations. Bohannon may have been rolling her eyes, but legally, she still had a right to trial. This shows the balance of the courtroom, strict on respect, but fair on rights. So let's recap. We saw two very different defendants today. Williams, buried under fines and community service, given one last chance to prove himself before facing harsher consequences. And Bohannon, whose eye rolls and excuses nearly derailed her case, but who still walked out with a jury trial date because the law protects her right to due process. Judge Bryant's courtroom makes one thing clear: respect the process, or the process will remind you who's in charge. What do you think? Were these defendants just overwhelmed, or were they playing games with the court? Drop your thoughts in the comments below. And if you found this breakdown as jaw-dropping as we did, make sure to hit that like button, share this video.
Turns out if you
Cursed at me because I'm good at reading.
No, I did not. You're just trying to start something. I did not just curse at you.
You said I'm trying to start something, girl. Who you talking to?
Look at
Who
you. You're being rude right now. I'm not even being rude to you. You've been rude all morning. I haven't even been rude to you.
My level best. I've tried my level best. And then she just had the nerve to say I've been rude all morning.
Welcome back to the channel, where we break down the most shocking and unpredictable moments from inside real courtrooms. Today's case is the people of Michigan versus Sierra Renee Urel, a seemingly straightforward assault charge that quickly spirals into one of the most chaotic pretrial hearings you'll ever witness. From a defendant visibly frustrated and hostile, to a judge who's forced to confront repeated disrespect, and an attorney-client relationship completely falling apart before our eyes. This hearing has it all. You'll see a defendant accused of assault who not only clashes with her lawyer but also risks losing her right to legal representation altogether. The judge's patience is tested, the prosecutor watches closely, and Sierra herself keeps pushing the boundaries of courtroom decorum. But the big question is, when does frustration cross into contempt, and when does self-sabotage seal your own fate in court? Stay with me, because every twist in this case will make you rethink just how far a courtroom will bend before it breaks.
Okay, I'm ready on Urel, and then Miss Urel, I believe I gave you instructions about remaining stationary, but I may not have. So I need you to be stationary. I need you to be seated in an upright position and ready to attend court. I cannot walk around on your camera. You're standing at the podium right now. We're standing at the podium. Yeah, I'm frustrated too. Can you put your head up, take your hands off your eyes, and let's pretend that we're in court. If we can't pretend that we're in court physically, then we shall be in court physically. So we either have to pretend that we're there and act as if we're there, or we shall be there. We shall actually be there in person, standing at that podium.
Right from the start, the judge sets the tone. This isn't a casual Zoom call. He insists Sierra sit upright, keep her camera steady, and behave as if she were in the courtroom. Because posture and presentation matter in court. Judges want respect, and appearing disengaged or frustrated only hurts your credibility. Sierra's body language, head down, hands over her eyes, signals defiance before a single legal issue is even addressed. This is a rookie mistake. Judges notice everything. Question for you. If you were in Sierra's shoes, would you have the discipline to treat a virtual hearing like an in-person trial?
This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urel. The defendant is charged with one count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Joseph Pernicano, P84918, appearing on behalf of Sierra Urel.
Ms. Urel, please unmute and state your name.
Sierra Urel.
What's your middle name, please?
Renee.
Do we need an adjournment, counsel? Or I don't know, it seems like your client is quite frustrated for some reason unknown to me. We just called the case, like we literally only called the case.
Sierra Renee Urel.
I was talking to counsel. Counsel,
Yes,
did we
Judge.
need adjournment? Did you need to talk to your client? I'm not real sure. How are you proceeding today? Because I'm not gonna proceed like with hostility. That's how stuff go left, and then stuff goes left. Sometimes it's just better to be in person because then people, I don't know, they act a little better. Maybe they act a little less hostile. I don't know, counsel, but how are we proceeding today? Because
Is it possible for me to have a breakout room with Ms. Urel? If not, then we would ask for an adjournment for an in-person hearing.
you can have a breakout with her. Did you know? You can have a breakout with your client for sure. And then
Okay.
that'll also give Mr. Haddad an opportunity now to talk to the prosecutor because he wanted to talk to the prosecutor. Did you know how you were proceeding with respect to your client, or you?
I lost
let me
contact.
let me just let you talk to her. Okay, that sounds good. I'll let you talk to her. Oh, I think my clerk had told me that somebody wanted to do that with their client. All right, I'm gonna send you. Okay, I'll send you and your client to breakout room number 15. Okay, I'm ready on Urel. This is case number 224557001. The people of the state of Michigan versus Sierra Renee Urel. Oh, this is a recall because I called it before. Okay, counsel, you've had an opportunity to speak with your client. How do you wish to proceed?
Here's the bombshell. Sierra's attorney moves to withdraw from the case. That's huge. Attorneys don't step away unless something has seriously broken down. He cites fundamental differences on the facts and law, a polite way of saying we don't trust each other at all. This tells us Sierra isn't cooperating, or worse, she's directly undermining her lawyer's strategy. When communication collapses like this, defense falls apart. And remember, this isn't her first lawyer. Judges take notice when multiple attorneys walk away. Think about it. Is Sierra sabotaging her own defense, or are her lawyers failing her?
Yes, Judge. At this time, would you entertain a motion to withdraw?
I guess so.
Judge, there has been a
Go ahead.
May I proceed? Thank you. There has been a breakdown in the attorney-client relationship. We have fundamental differences regarding our understanding of the facts in this case, as well as the application of the law to the facts. Based on that, I would motion to withdraw at this time, again, as there has been a breakdown in the attorney-client relationship.
And Ms. Urel, do you agree with that assessment by your counsel?
I guess.
Okay, I guess. And then counsel, you were retained, correct?
No, Judge, I am appointed on this matter.
Oh, okay. You're appointed.
Yes, Judge.
So does that mean that, let me get Ms. Stevenson. Hold on.
We were planning our anniversary.
Give me 1 second. Ms. Ritter, can you join me and Ms. Stevenson in breakout room number 1? And then counsel, I may need you also, but give me a moment. Ms. Ritter,
Yes, Judge.
me and Ms. Stevenson in breakout room number 1.
Yes, ma'am.
So I had an opportunity. I was trying to figure out, after you said you were appointed counsel, I was trying to figure out why you would have been appointed, because we have, defender's office. And so that's why I went in to speak with Ms. Stevenson. And then she brought it back to my remembrance. So I'm getting ready to say this to Ms. Urell. You're going to find yourself in a situation where you're going to be representing yourself, because Mr. Pernicano is the second lawyer.
The judge now reminds Sierra this is her second court-appointed attorney. And here's the catch. When the court gives you an attorney for free, you don't get unlimited do-overs. Switching lawyers repeatedly looks like manipulation. Judges call it lawyer shopping, stalling the process until you find someone who tells you what you want to hear. But courts don't play that game. Unless you hire your own attorney, you take who's appointed. And if Sierra burns through them all, she might be forced to represent herself. Audience question: do you think she deserves one more lawyer, or has she lost that privilege?
That I've had appointed to you. Miss Urell, I need you to look at me, because you're looking up in the ceiling. So this Mr. Pernicano is the second lawyer that I've had appointed to you. And the only way that we do apple picking when it comes to picking lawyers is when we hire our own lawyers. So when you hire your own lawyer, then you get to decide what lawyer you want. You get your lawyer of your choosing. And then I was reminded that your mouth was foul when it came to your lawyer. And people don't have to put up with people being disrespectful and rude and whatever. Again, you're looking up in the ceiling. And I'm trying to be patient this morning. People don't have to put up with being cursed at when they're trying to represent you. People don't.
Now the tension explodes. The judge calls Sierra out for allegedly cursing at her lawyer and even at the bench. Think about that. Two people assigned to help her, and she's alienating both. Courtrooms run on respect, and cursing at a judge is like playing with fire. Even if you're innocent, disrespecting the court can land you in contempt, fines, or even jail time before your case is decided. The judge is remarkably patient here, but you can feel her reaching the end of her rope. Would you say Sierra's just frustrated, or flat out sabotaging herself?
And I think you just cursed at me because I'm good at reading.
No, I did not. You're just trying to start something. I did not just curse at you.
You said I'm trying to start something, girl. Who you talking to?
Look at you. You're being rude right now. I'm not even being rude to you. You've been rude all morning. I haven't even been rude to you.
My level best. I've tried my level best. And then she just had the nerve to say I've been rude all morning. She just said I've been rude all morning. I mean, that is so hilariously funny. I can't even put that to words. So what I'm going to do is this. We're going to all just come on in downtown. And then I won't even have to read lips. I won't have to. I mean, I've literally not. She said I've been rude all morning. I've literally not said anything about the fact.
I just tell you what you said.
I've literally not said anything about the fact that Miss Urell is like literally in the bed. I've not even addressed the fact that she's in the bed, and she said I've been rude all morning. And then thankfully, I don't care if you're sitting up. It is inappropriate to come to court sitting up, laying down, sitting over the bed. I don't care if you're sitting up. I know you're sitting up. I can clearly see with my eyes that you are sitting up, because contrary to to your belief, because not popular belief, I'm very intelligent. I can see that you're sitting up in the bed. What I also know is that you have been rude, and you cannot maintain a lawyer. I'm not inclined. So here's the situation we find ourselves in right now as you keep on talking, right? And the only reason that we can't hear you, and it's not a disruption currently to the record, is because you were on mute. And in this moment, the court is not going to allow you to unmute yourself. So here's the situation. I don't have to keep giving you a lawyer. You're confused in your thinking. I have given you 2 lawyers free. I've given them to you. I've provided them as according to what the law requires. And this is the second lawyer that the court has provided for you that wants to withdraw. It's the second lawyer.
At this point, the judge grants the attorney's withdrawal. Translation: Sierra is officially without a lawyer. This is a worst-case scenario in criminal court. Judges hate when defendants end up unrepresented, but here the judge makes it clear: enough is enough. Sierra's attitude has consequences. The judge hints she'll ask the Indigent Defense Office if they'll risk assigning her a third lawyer, but makes no promises. And here's the harsh reality: if they refuse, Sierra either hires her own lawyer or defends herself. Imagine walking into trial on an assault charge without a trained attorney by your side.
So here's the situation. I'm going to allow counsel to withdraw.
Your workflow is important to us. Please wait indefinitely.
And then Miss Urell is going to have to try to get her some more counsel. Miss Urell is going to have to get her own counsel. Or Miss Urell is going to have to represent herself. I will talk to the Michigan Indigent Defense Counsel office and see if they're willing to appoint one more lawyer for Miss Urell. And I believe the answer may be no, because what we're not going to do is keep appointing lawyers for Miss Urell to curse out or be rude to or decide that she knows best on how to do the case. That sounds like Miss Urell needs to represent herself because she believes that she knows best how to do that. So we're going to come in person. Mr. Flanagan, we'll talk about it after the docket, but Ms. Urell needs to try to see if she can hire her own lawyer. If the MIDC appoints another lawyer to this case, and let me just let the record reflect. I know it can only be reflected in the video as opposed to in the verbal record because Ms. Urell is on mute.
Even on mute, Sierra can't hide her frustration. The judge narrates her body language for the record, slamming hands together, hands on her head, mouthing off silently. This is crucial because courtroom records aren't just words. Judges document behavior to protect the record on appeal. Sierra's visible hostility is now part of her case history. And if a jury one day hears about this, it won't help her credibility. Remember, in court, even silence speaks volumes. If you were her lawyer, how would you even begin to repair this kind of damage?
She is slamming her hands together. She is continuously talking while the court is talking. She is slamming her hands together. She now has her hands on her head, and it's just inappropriate. So we're going to come in person in 2 weeks, and we're going to see if we can get another lawyer to do the case. And if not, that's fine too. Ms. Urell, today is January 17th. We're going to come January 31st in person. So we're going to set this in person at 9:02. Counsel, you are let the record reflect that Ms. Urell does have her hand up, and I am going to allow for her to unmute, but I'm going to state in advance and for the record that if you are rude, if you are yelling, if you are anything other than, and then let the record reflect that she is also sent directly to me, which is inappropriate, right? She has sent a chat saying, so I'm trying to figure out figure out you just not go, let me say none, N-U-N. So that's what's in the chat. So let me just indicate.
When Sierra finally unmutes, she erupts, "You ain't asked me not one question." To her, the court is ignoring her side of the story. But here's the truth. Pretrial hearings aren't about telling your full narrative. They're about procedure, representation, and scheduling. The judge did ask her if she agreed with her lawyer's request to withdraw, and she said, "I guess so." Her outburst shows frustration, but also confusion about how the system works. This highlights a bigger issue. Many defendants misunderstand courtroom stages and end up digging themselves deeper. Should judges explain more, or is it the defendant's job to learn?
For the record, that is inappropriate to say to the judge. That's it's disrespectful. And if that's how you're going to talk to me, when I unmute you, I'm going to immediately mute you back. And then it appears that we might need to submit the matter for a competency evaluation. But I'm going to allow you to unmute, and you're going to be respectful to me, or I'm going to mute you back. And there's nothing funny going on in my courtroom. There's nothing funny. So again, if we're not going to be respectful, then we're going to go back on mute. Okay, so you can unmute yourself, Miss Urel.
I could talk now.
This is the wonder oven pro from our place. Our next
Miss Urel, what do you want to
I
say
just
to
asked,
the
could
court?
I speak, and you just looked around and didn't say anything.
Miss Urel, what do you want to say to the court? This is my last time asking you.
Okay, what I want to say to the court is, how y'all just go off of what some lawyer saying? You ain't asked me not one question. You ain't asked me nothing. You ain't asked me nothing.
First of all, lower your voice because you're yelling at me.
Because
Second
you
of
sitting
all,
here trying to make it just off of what a lawyer said.
First of
I
all,
was
you're
never
yelling at me,
disrespecting him.
and I'm not going to allow that. Second of all, I specifically said, so let's rewind.
No, I know exactly what you said.
Because your memory is failing you, and let the record reflect that I've muted Ms. Sherelle. So when counsel asked to withdraw, I specifically said, Ms. Urel, do you agree with that assessment? So you said, I didn't ask you nothing. You said, I'm just going by what some lawyer said. And when counsel asked to withdraw, I specifically said, Ms. Urel, do you agree with that assessment? And then Ms. Urel said, I guess so. That's what Ms. Urel said. So let the record be clear.
The judge quickly corrects Sierra. She did ask if Sierra agreed with her lawyer's withdrawal, and Sierra agreed on the record. This is critical because Sierra accused the court of bias, but the record proves otherwise. Judges are meticulous about documenting these exchanges because defendants often claim, "Nobody asked me." The transcript shows Sierra gave her consent. That matters, especially if she appeals later. This moment is a reminder that facts live in the record, not in emotions. Question for you. When Sierra said, I guess so, do you think she truly understood what that meant?
That I, in fact, asked Ms. Urel if she agreed with the assessment. So I'm going to go ahead and set the matter for January the 31st for a final pretrial conference. It is in person at 9:02. We are going to contact the Michigan Indigent Defense Council to see if they will appoint a third lawyer for Miss Urell. This will be the third and final lawyer appointed. If this relationship does not work out for Miss Urell, then we are going to let me disable the chat because Miss Urell continues to speak to me in the chat, which is inappropriate. So I'm going to disable the chat. And then we are going to, Miss Urell, if you would stop yelling, if you would pay attention, then I would take you off mute. But like literally right now, you're yelling, literally. And the only reason that we can't hear is because you're off mute. Now, what I'm going to do.
Here comes another twist. Sierra sends a chat to the judge asking, "Can you let me know if you're going to lock me up?" On one hand, this shows genuine fear. She's worried about childcare and planning her life. On the other hand, it shows a misunderstanding of what today's hearing was about. This wasn't sentencing, it was procedural. The judge hadn't even suggested jail yet. But by asking that, Sierra reveals she doesn't trust the process. It's a human moment, but also a red flag. Should the court show more compassion, or is Sierra making her own problems worse?
Well, let me just read for the record what she sent to me directly in the chat, which was inappropriate. Can you let me know if you're going to lock me? Let the record reflect that she's clearly, like, she's, even in this moment when I'm trying to read what she wrote in the chat, she's literally yelling. But the only reason we can't hear her is because she's on mute. So she chatted me, and Madam Prosecutor, and her chat says, "Can you let me know if you're going to lock me up?" No, okay. No, KNOW. So I can get my babysitter in order. Now, what's interesting to me is that I've not said anything about locking anybody up. We're coming in like I'm literally trying to get Miss well, let me say this to you. So you can unmute, because what's going to happen is if you keep cursing at me.
And now we reach a turning point. The judge orders a competency evaluation. This isn't about guilt or innocence. It's about whether Sierra understands the proceedings and can participate in her defense. If she's found incompetent, the case pauses until she's evaluated or treated. If she's competent, she moves forward, possibly without a lawyer. Either way, this decision changes everything. Judges don't make this call lightly, but Sierra's behavior, defiance, confusion, hostility, forced the issue. Competency isn't about intelligence, it's about legal awareness. Do you think the judge made the right call here, or was this an overreaction?
Why you should never cover your credit card with tin foil. I've worked at a major bank for 14 years.
Happen is you are going to get locked up. Now, it's
that's
not
your goal anyways. That's your game plan anyways.
You don't know what my game plan is. You don't know anything about me. You don't know anything about me. So we're going to come in person January 31st at 9:02. We're going to contact the Michigan Indigent Defense Council, and we're also going to order a competency evaluation. So this is third lawyer. January 31st at 9:02 in person. Mr. Pernicano, you are discharged from the case. Everyone have a great day. Stay safe. And we'll see people on the 31st.
The hearing ends with Sierra's lawyer officially discharged and the case adjourned for an in-person hearing. This means Sierra has a short window to either secure her own lawyer or accept the court's final appointment. The clock is ticking. The judge has been patient, but her message is clear. This is Sierra's last chance. One more breakdown, and she's on her own. For a defendant facing an assault charge, that's a dangerous gamble. But here's the bigger takeaway. Courtroom patience has limits, and when defendants test those limits, the consequences can be irreversible. So let's recap. What began as a simple pretrial check-in became a full-blown crisis of representation. Sierra Euro clashed with her lawyer, clashed with the judge, and now faces the possibility of representing herself in a criminal case. The judge ordered a competency evaluation, scheduled an in-person hearing, and left the door cracked open for one final lawyer, her third. This case is a masterclass in how courtroom behavior can impact your future as much as the actual charges. Now, I want to hear from you. Do you think Sierra is being unfairly judged for her frustration, or is she her own worst enemy in this courtroom? Drop your thoughts in the comments. And if you found this breakdown as shocking as I did, make sure to hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom drama breakdowns every week.
Inappropriate and it's disrespectful for you to come on this Zoom with that face cream on the day of your sentencing. This is not a game. It's not a joke. We come to court professionally attired, and that is absolutely disrespectful. Now, please go wash your face and come back prepared for court. All right, Ms. Stevenson, I got one more case before you. Well, now I don't. They keep leaving. They keep leaving at different times and coming back and leaving and coming back. Oh, no, there he is. He's still here. Okay, there he is. I have one more case in front of you. That's Miss Castall's case. And that is Chicago. However, I don't know that the I might have another one, but I'm gonna do a couple of yours and then I'll do I'll also have Cone, the attorney for Cone. Mr. Chicago, I need you to start your camera.
I'm trying to turn my camera on.
Oh, Miss Chicago.
Yes, I'm sorry. Okay.
Ma'am, you coming to court with facial cream on your face? That's inappropriate. Ma'am,
okay, I'm sorry.
No, listen to me. It's inappropriate and it's disrespectful for you to come on this Zoom with that face cream on the day of your sentencing. This is not a game. It's not a joke. We come to court professionally attired, and that is absolutely disrespectful. Now, please go wash your face and come back prepared for court. I'll bring you back out when I'm ready in a minute when you wash your face. Mr. Landis, I don't believe you would have received a copy of the pre-sentence report because we wouldn't have known that it was some out-county prosecutor. Do you need the pre-sentence report?
I do not, Judge. I appreciate the offer, but I think the offer is, where this is going is stated in the plea agreement. So,
and you don't know me, you might need that report.
And Your Honor,
I
did email it to you, Mr. Landis.
Oh, okay.
Thank you.
Let me make sure. I know he was like, we pretty straightforward. There's nothing straightforward in here.
So, Your Honor,
assault and battery. What's this larceny stuff? Do you see this report? And do you see plea agreement and say larceny in a building and larceny pled guilty? That's not right.
No, it's not, Your Honor. She was only charged with the ethnic intimidation, stalking, and the assault and battery. The ethnic intimidation and stalking were dismissed, and she pled to the assault and battery. So that on there is incorrect.
Well, now that makes me nervous about everything else that's in here. But did you go over this with your client?
I did, Your Honor, yes.
Okay, well, I'll get to that then in a minute. While your client washes her face, I'm gonna handle a quick pretrial conference with Ms.
I apologize, Judge, on behalf of Ms. McCoggle. My apologies. I was not aware.
Yeah. All right, thank you for the apology though. All right, I'm ready. And ma'am, your full name, please.
Mita Lynisse Renee McCoggle.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
No, thank you, Judge.
On behalf of the defense?
Yes, Your Honor. On the first page, I think we discussed this off the record. It indicates that there was a plea agreement for larceny in a building, which was dismissed by party, and then the larceny 200 plea guilty. That information is incorrect, Judge. So I just ask that that be stricken from the pre-sentence report.
Court will strike that from the report.
Thank you, Judge. I have gone over the pre-sentence report with Ms. McCoggle. To our knowledge, it is factually correct. No other additions, deletions, or corrections to be made.
Thank you. With respect to sentencing, is there anything on behalf of the people?
No, thank you, Your Honor.
Anything on behalf of the defense?
Judge, I just ask that the court follow the plea agreement that was entered into between the prosecutor's office and us.
And what is that agreement? Because it's not listed on the reports.
Judge, that agreement was for 9 months reporting probation, which may be telephonic reporting at the discretion of the probation officer, mandatory drug evaluation and following any treatment recommendations, and no contact with the victim, Jaleesa Abad.
That's correct.
Okay. Just for future references, there's never anything that I leave in the discretion of probation. Cheers. Court is going to impose. I apologize, Ms. McCoggle. Do you want to make a statement on your own behalf?
So the drug evaluation, will I have to
I didn't say ask me any questions. I said, do you want to make a statement on your own behalf?
No, I guess not.
Okay. Then the court is ready to impose sentence. I will do so in the following manner. There is a recommendation from probation for a probationary period of 9 months, which appears to be in line with the sentencing recommendation from between the parties. The court will accept that and sentence Ms. McCoggle to a term of probation for 9 months. That being a final review date of May the 2nd, 2024 at 10:00 a.m. with the following terms and conditions. Ma'am, you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent from this court. You must make a truthful report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. Oh, give me 1 second. Ms. Stevenson, I'm going to try to send, oh, no, she just went off. Okay, that was distracting. You must pay the following fines, costs, and fees. The court is going to impose the mandatory cost of $210. Additionally, according to page 5 of the pre-sentence report, it indicates that she was unemployed at the time of the interview, but that she had a job offer with a deli. Ms. Castall, do you know the status of her employment?
Your Honor, that didn't go through, so she is still unemployed.
All right, then the court is going to impose 10 days of community service in lieu of the additional fines, costs, and fees, with the exception, of course, of the cost for the classes. Court is going to, so the total cost is $210. Additionally, ma'am, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. According to the report, your license is suspended and your driving status is ineligible. You shall attend and complete 12 weeks of anger management, preferably through the EVA program. Ma'am, what you doing?
Nothing, just moving to another room.
Right, why? Because I'm in the middle of your sentencing.
I know, I hear you. I'm listening. I was just moving to another room.
Don't move to another room. Otherwise, we're gonna come in person and then we'll never have to move out of that courtroom.
Yes, ma'am.
"12 weeks of anger management, preferably through EVA. She will submit to a mental health evaluation. She will submit to urinalysis once a month for 3 months. If I'm satisfied with the results, then she can discontinue. So that actually means I'm going to impose $30 more on her fines, costs, and fees. So that would be $240. $30 would be for the 36th District Court urine screening. And then you shall pay all outstanding tickets that you have with the 36th District Court or get on an approved payment plan. We're going to come back to me after the 3 months so that I can see if there are any additional referrals needed, if I need to refer her to any specialty court based upon her mental health evaluation or her urinalysis. So the court is going to set a review date for November the 2nd. Hold on, that might not be right. I might not be available. Oh yeah, I am. November the 2nd is the review. At 10:00 a.m. We will mail a copy of this report to the Concord Street address. Probation will contact you at the phone number ending in 4281. Is there anything further with respect to Ms. McCoggle?
Your Honor, I just do have a question for the court, and I don't make a difference. Ms. McCoggle does go and get therapy at Team Wellness. So I don't know if that'll make a difference as to the court's requirement that she submit to a mental health evaluation.
No, thank you for bringing that to my attention. So instead of the mental health evaluation, I am going to indicate that she will continue counseling through Team Wellness. Also, I'm sorry, I forgot to indicate, according to the report, now, based upon this misstep on page 1, I don't know if we're going to need to confirm, probation will need to confirm this, but it indicates that Miss McCoggle has 1, 2, 3, 4, 5, 6, 7 warrants for her arrest. She must clear up all outstanding warrants. All right, so she needs to confirm that with probation. Yes, ma'am.
Some of those are from 36. Will she be appointed a misdemeanor attorney so that she can get those taken care of? At least the ones for 36.
I see 2 for 36. Strike that. I see 1, 2, 3, 4, 5 for 36. And the answer to your question, generally speaking, is that House counsel is available to anyone in traffic courtrooms who wants to utilize them.
Thank you very much for
So
that.
she needs to work with her probation officer to make sure she gets a court date for those cases at 36, and then you know, whatever else out with the other ones are out of 43rd District Court.
Thank you, Your Honor.
All right. Anything further?
Nothing further from the people. Thank you, Your Honor.
Then we're all set, Ms. McConaughey, until November the 2nd. But Ms. McConaughey, I need to let you clearly understand that when you come on Zoom, we're in court. Don't ever show back up in my courtroom with face cream on your face or walking around. We're
Yes, ma'am.
stationary, seated in an upright position, and ready to attend court at all times while
Yes, ma'am.
we're in court. And I would appreciate it also if you wouldn't try to interrupt me and rush me.
Mr. Watts would like to start his employment with Burger King. He states that he has had the interview and he looks to work and would like to be released on tether so he could do so.
Mr. Watts is gonna get fired from that job on the second day because Mr. Watts is combative and not participating, and he keep walking away. And because he did not let Judge Holmes and her staff address his issues, that's why, and look at him, he getting ready to try to call himself on overtalk me, but I am the queen of not being overtalked. Chantel Phillips, whatever that is on your head, please remove it. Mr. Irving, you cannot be in a moving vehicle.
I'm not driving, though. I still can't be in a moving vehicle.
I don't understand why the people always respond to me and say I'm not driving, as if I can't see what side of the car you're sitting on. So here's
His name for the record.
all right. So Mr. Watts has been returned to my courtroom because he's been kicked out of the specialty court program. I have been informed that Mr. Watts has been violated numerous times, that Mr. Watts refuses to go to treatment, that Mr. Watts continues to walk away from the program, and that he does not want to participate. Ms. Spann?
Judge, that is correct. Mr. Watts has had several issues. I believe that the mental health court and that assessment would fit his circumstances much more so than the substance abuse program that he was in.
No, don't let Mr. Watts fool you. That ain't, Mr. Watts was in mental health treatment court. Mental health treatment court is a dual diagnosis court. Judge Holmes is the ultimate expert on specialty courts. Judge Holmes would never have Mr. Watts just somewhere in drug treatment court when he clearly has mental health issues. No, Mr. Watts has been kicked out of mental health treatment court, and he cannot go back. And he is here before this court now for revised sentencing because they have kicked him out of the program, and he cannot go back to sobriety court, to mental health court, to veterans court. to community court. He can't go back to none of the specialty courts because they're sick of Mr. Watts walking away and violating, having to be found, having to go to jail. Mr. Watts don't want help. Mr. Watts don't want help. Mr. Watts want to stay on drugs, and he want to stay with his mental health issues. He does not want any assistance. Now, another response, Ms. Fan?
Well, Mr. Watts would like to start his employment with Burger King. He states that he has had the interview and he looks to work and would like to be released on tether so he could do so.
Mr. Watts is going to get fired from that job on the second day because Mr. Watts is combative and not participating, and he keep walking away. And because he did not let Judge Holmes and her staff address his issues, that's why, and look at him, he getting ready to try to call himself on overtalk me, but I am the queen of not being overtalked. I'm the queen of not being overtalked. So we're not going to do that. I'm going to tell you my intention, and then I will allow you and maybe your client to have a response to my intention. It is my intention to revoke Mr. Watts' probation. I am going to sentence him on case number 224414001 to 93 days in the Wayne County Jail. Case number 224483401 to 93 days in the Wayne County Jail. Case number 224428601, 93 days in the Wayne County Jail. That is my intention. Ms. Spann, anything further?
Judge, I would just like to request that those run concurrently and he be given credit for any time served.
The 3 cases will run concurrently, and unless the law requires it, I'm not going to run them concurrently. But if the law requires it, then they gonna run concurrently. So I guess I better find out. Mr. Watts, you can unmute. You can unmute.
Judge, I was trying to ask you. Yeah, I got a job interview on the way. And
you should have thought about that when you kept walking away from the program. You should have thought about that job interview when you kept walking away from the program. Your sentence was to go and participate in mental health treatment court. You have decided that you did not want to do that. Now, what would make me think? What would ever make me think that I was going to be able to do anything with you on probation when you clearly keep walking away from all of the help that we are trying to get you? So that job interview
I'm not on drugs. My daddy
that's why you were in the mental health court. That's why you
I know my daddy gave me a phone. I got my ID and social security.
Yeah, they told me that your father came up to the place and brought you a bicycle. They told me your father came up to the place and set a bicycle outside of the treatment place, and you got on the bicycle and rode away. Yeah, I know all about it, Mr. Watts. I know all about it. You ain't coming in here with nothing, no whatever. So anyway, court is going to send that. That is my sentence. I have not changed my mind. And then hopefully one day, Mr. Watts' father and whoever else is around him that is accommodating his refusal to get treatment, perhaps those people will stop enabling Mr. Watts to remain where he is. I think the father should be charged with something, but that's just me. But that's my order. I'm revoking probation. He is sentenced to 93 days on each count. I do understand that Judge Holmes at some point gave Mr. Watts 45 days in the Wayne County Jail, but that was for a violation. That was for a violation. Those 45 days do not count toward the 93. The 45 days do not count toward the 93. Look like he just knocked down the jail camera. They probably gonna come get him, and then he gonna have another charge because he went side. Did you see him jump up and then look like he knocked out the jail camera? So the 45 days, he's not getting credit for the 45 days. But if he served any other time outside of the 45 days, then he can get credit for that time.
Thank you, Judge.
You're welcome. I guess they're gonna have to log back Miss Terry on another camera because it looks like Mr. Watts broke their camera. That's what that looked like. Okay. All right, I'm ready on
Oh, okay.
Chantel Phillips, whatever that is on your head, please remove it. Gina Whitfield, please start your camera. Mr. Irving, you cannot be in a moving vehicle. You cannot be in a moving vehicle.
I'm not driving, though. I still can't be in a moving vehicle.
I don't understand why the people always respond to me and say I'm not driving, as if I can't see what side of the car you're sitting on. So here's the thing I say, you cannot be in a moving vehicle. We are in court and we're not moving in vehicles. So I'm gonna send you, sir, please be, sir, okay, please be quiet at this moment. I'm gonna send you all to a breakout room. All right.
All right, Leandre Ramon Irving.
Now that's not going to be able to happen. Now, first of all, you keep moving around and you putting your ear up to this phone. Now, this is really distressing to me.
All right, apologize for that.
It's distressing to me for a number of reasons. This matter is scheduled at 9:10. Mr. Irving has on a white t-shirt that is inappropriate for court. He is putting his ear up to this camera as if this is not at least his third or fourth time appearing to this court. And by the third or fourth time appearing to the court, most certainly Mr. Irving should know proper courtroom etiquette and decorum. But it appears to me that he does not. He has logged on this morning and has been inappropriate at every step. Ms. Stevenson, how are we continue? But in the future, if you had your clients come in with these undershirts on for court, I'm just going to delete them. I'm just going to delete them out.
Yes, Your Honor.
How are we proceeding?
Your Honor, we would continue the matter, continue our jury demand at this point. I think there's a jury trial scheduled for November 28th, Your Honor.
And Ms. Ritter, will the people be ready to proceed? It seems like I must have wanted the people to confirm their witness if the trial isn't until November. You said November what?
28th, Your Honor.
When the police submitted their information, who did they put down? They didn't put down anybody to say this who has the child is in the custody of this person right here and this is their contact information?
Well, on the police report, Judge, there is a listed address.
I need the police and everybody to do better. Okay, I need everybody to do better. Okay, so there's an address, but no phone number for an adult who has care, custody, and control over the minor child. Well, let me say this. I quit on Mr. Irving. I quit. He has to come in person. I quit on him. All right. We're going to adjourn the case. Mr. Irving has to come in person. Let's see. Monday, July 24th, Mr. Irving has to come in person. And Ms. Ritter, maybe by that time, the OIC or somebody can go out to that house.
Yes, Judge, I'll get in contact with the OIC to make location or to make attempts to the location again.
In person only, in person, and properly attired. No shorts, no flip-flops, no beater shirts and stuff. A properly attired for court. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Irving at this time. Thank you, Your Honor.
I said, have a great day. Stay safe.
There we go. All right, everybody. That's basically what. How do I have to explain? If I have to explain it, okay. When you're in a Zoom court appointed Zoom meeting, okay, you will dress and you will act with respect to the court and to the judge. You need to remember, these judges can get you for contempt of court if you're misbehaving. People are just idiots sometimes, I wonder. So, yeah. When you go, if you're in a Zoom meeting in a court, you need to look, you need to be, I'm sorry, you need to dress appropriately, act appropriately. Don't be moving around. Don't be in a moving car. Don't do it. And the thing is, these judges ask for respect. If you're not going to give your that guy got 93 days twice. I think it's 200 and he got almost a year. He got 200 something days in jail just because of his conduct. So think about it before you act. All right, well, that's it for today. I will see you guys tomorrow. You all have a wonderful evening. Ta-ta, ciao, and I will see you again soon.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, I was standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's over.